Hi everyone, I would like to welcome our viewers, both returning and new, to this interview being part of the Young Commonwealth Lawyers Association interview series, which aims to highlight issues affecting young lawyers and by extension, young professionals in today's world. I am Chloe Macmillan and I'm an attorney at law from the beautiful Twin Island Republic of Trinidad and Tobago. And I have been a member of the Commonwealth Lawyers Association and a committee member of the Young Commonwealth Lawyers Association since August of 2020. I qualified to be an attorney at law in Trinidad and Tobago in July of 2014. And I'm also called to the Bar of England and Wales in 2013. I specialize in civil litigation with emphasis in family law. Today, we shall be exploring the impact of the COVID-19 pandemic on employment. These unprecedented challenges are having economic ripple effects, globally, as countless persons are either out of work or the way that they are working has completely changed. Although the full impact of the pandemic on employment is still unknown, we are able to identify and discuss some of the main effects that are affecting employees and the workplace. I have the honor and pleasure of interviewing an experienced employment solicitor from the UK, Ms. Eileen Schofield, who has graciously agreed to be a part of this discussion on this important issue. So let's dive right into it. Hi, Eileen, how are you today?
I'm really well, thank you, Chloe. Thank you.
Can you give us a brief introduction about yourself and your professional background?
Absolutely, thank you. Thank you very much for the opportunity. I feel very privileged to be speaking about employment law and also from the UK, speaking about employment law. So I joined the profession when I was a mature student. I went to university with two young children who were very young, actually. In fact, I had my second child in my second year at university. So I carried on studying, completed my qualification, and actually took a little while before I got a training contract for all sorts of reasons that you might imagine. They're asking me about my children, people who are interviewing me. So there was lots of employment law issues, which I didn't know about at the time, but they were fine. I eventually got a training contract and qualified in 2000. I worked for a corporate national law firm, very large law firm, and did my training contract and qualified into the employment law team. So I qualified, as I say, in 2000 and have been working in employment law ever since. I set up my own firm in 2009, and since 2009 we've grown. We're an international practice. During that time, I have been elected to President of Birmingham Law Society. I was the first female chair of the board of Birmingham Law Society and sit on a number of boards as a director and trustee and I'm a school governor. So really enjoying the world of employment, but also enjoying the opportunity to run my own business and to employ a number of people.
Great. So let's talk about the issue of work from home. As we're going through the COVID-19 pandemic, we've been hearing about work from home, working from home rather, is ever increasing and seems to be sticking around as we are muddling through the pandemic. There's a concern from junior attorneys, junior lawyers, that they may feel deprived of opportunities and in turn career progression due to the absence of face-to-face contact with more senior members of staff. What would you suggest to juniors and indeed supervisors to ensure that there's career development?
So the UK is, we're in a state of, well, not lockdown, we've removed the lockdown, but people are encouraged to work from home. I would say that definitely in the West Midlands, there is a move to bring people back to the workplace. The preference for law firms particularly, and they're different from other sectors, is that they will bring people back into the workplace as soon as possible for exactly the reasons that you're talking about. You know, law is a collaborative profession. We work together, we learn off each other, we listen to people on the telephone, we listen to how they communicate with clients and with each other, how they run arguments. So all of that has had, you're absolutely right, an impact on the more junior end of the profession. who learn from the people that they sit with and learn from what how the seniors handle themselves in meetings and with clients. So what's been happening with a lot of law firms is that they have adopted a more significant use of Teams. So people, young lawyers will be encouraged to sit on Teams. It's a lot of computer-based interaction. That is the best we can offer at the moment to our young members of the team, but encouraged to use that to the maximum benefit. So stay on Teams most of the day, sit with the supervisor on Teams, interact, ask questions, use the chat box. Don't be shy to ask any questions. Just because young lawyers or lawyers who are newly qualified, they're not always young, as in my case, but young lawyers who are newly qualified would ask the questions in the workplace. There are no questions that are too simple or questions that shouldn't be explored. Situations should be explored, and to ask the questions means that you're interested, shows that you're dealing with a situation, and shows that you're prepared to communicate with your senior and want to learn. So use all of the technology that's available, excuse me, to you working from home. And if you have an opportunity of going into the office, don't be shy about going into the office. Make the most of that relationship.
Great. How, as far as you're aware, how has the pandemic affected the workforce in the UK?
In the legal profession or generally?
In the legal profession.
There have, well, in fact, it's really quite interesting. So for many, many years, we all asked for the opportunity to work from home from time to time. And of course, the legal profession said, well, that's not at all possible because we're not set up to work from home. And actually the whole collaborative piece of working together is done better in the office. So unless you've got a really good reason, then you can't work from home. However, hit the pandemic and within 10 days, every lawyer in the country was working from home. So it can be done. Mm-hmm. So it has been done and it's proven to be a success. In the first lockdown, and in the UK, we've had 3 lockdowns. In the first lockdown, the feedback that I was getting from managing partners was that productivity increased. You know, people were working from home, they were committed from working from home, they were set up, they had all the equipment that they needed, and that productivity did increase because obviously solicitors, lawyers, teams were not having to travel, so they were starting working at 6, finishing at 6 or 7, whatever their requirement was, and there was no real distraction from the point of view of meetings. So there was a significant increase in productivity. Subsequent to that, there's been a little bit more of a dip, but now, you know, there is sufficient productivity to justify people to continue to work from home. So the COVID has had a massive impact on the way in which businesses are now engaging with their employees, their lawyers, and looking at different ways of working going forward, which is fantastic. You know, a lot of people want to work in the office, so that opportunity will be open to them. But if people want to have a hybrid method of working, which we've all talked about for many months, then that's now going to be a genuine opportunity for people.
Okay. I for one know I enjoy working from home, so I hope that, you know, it's something that could stick around later on post-COVID.
Yes, yes, yeah.
All right, so we're hearing a lot about the word furlough. Can you give us your views on the effectiveness of this scheme?
Well, actually, you know, furlough was never a term in the UK employment law. It was a surprise to all of us as employment lawyers when the Chancellor released a statement to say that they would be applying a furlough scheme, the job retention scheme. Now, the definition of furlough is an American term. Actually, it was used in the armed forces in America, where people who were no longer out on the operational service, they were put into furlough, put into the leave, furlough leave. So they were put out in the garden really effectively. So that's where the term has come from. So it's really removing people from the workplace whilst they're still receiving the benefits. So that's the origin of the term furlough. I happen to think that there's an awful lot that could have been done better in the UK, and that will be history, and we can unpick that for as long as we like going forward. But one of the real successes has been the furlough scheme. What it's meant for businesses is that if they couldn't operate in an effective way and their employees couldn't work from home and their business had changed significantly almost overnight, then they weren't going to lose that talent, but they could also have the benefit of being paid to retain that talent. So the first stage of furlough was an arrangement whereby an individual would be paid £2,500 as a maximum amount and equivalent to 80% of their salary. So that was capped at £2,500. They had the benefit of working from home. There were terms and conditions attached to that, and they couldn't participate in any aspect of work, but they could undergo training to make sure that they were keeping up to date with their area of specialism as lawyers or any other sector. So it's been a fantastic success, I think. It's been extended. It was due to finish in October. Last year, it's extended to April, and then because of the new strains of COVID, the government has not relaxed our restrictions, so it's now been extended to the end of September. There are different changes to how much an employer has to pay now, but equally, it's a really effective scheme. And outside of the legal profession, other sectors such as hospitality has had a phenomenal benefit from that. And of course, we're all wanting to support the arts and culture. They've not been operating at all. Sports, hospitality, all of these are really important and valuable sectors to all of our economy. So the furlough scheme has enabled those businesses to remain viable, whilst also retaining their skills, their talent in the businesses. They have trimmed down, and I know we'll come to that in a little bit later in your interview.
Yes. All right. So all in all, furlough has been a great scheme so far. So with regards to the COVID-19 pandemic, do you believe that young lawyers or young people generally are disproportionately affected by the pandemic? So for example, some workplaces might do the last in, first out method, therefore affecting possibly the younger workforce who may have just started working. What are your views on that?
So in the UK, last in, first out is no longer an acceptable method of releasing people from, let's say, a redundancy situation. So that's been abolished, so we can't use that as a criteria. But notwithstanding that, I absolutely agree that the younger professionals have been more significantly affected. And for the reasons we said earlier, the training has not been as effective as it might have been if young professionals were allowed to work with their supervisors or in fact their team in an office. So the training has not been as instructive. There has been training, without a doubt. Law firms have taken that responsibility really seriously, but the intensity of the training is quite different. And I think the responsibility has fallen on young professionals to follow through with their own commitment and use their own initiative to training. And that's never a bad thing. But I don't believe that this time out of the office has served them well. Law firms have stopped recruiting trainees to the same degree, and trainees have started and have not met their supervisors or their team. So it has been a significant impact on everybody, but particularly young professionals. And the reality is that nobody could do anything about that. There's nobody to blame, obviously. It's an international global pandemic. Some law firms are encouraging younger professionals to come into law practices, to law firms, where they know that they're going to need more support than maybe the more experienced listers. And, just on a personal level, we have regular meetings with lawyers as part of the Law Society Council meetings. And I see that lawyers working from home are working in their apartments. You know, young lawyers have bought apartments in the city centre, for example. Their anticipation when they invested in their apartments was that they were just going to use that somewhere to sleep. They didn't imagine that they were going to live there, as in work from their apartments. So they thought that they'd have a fantastic social life, that they would only be going home to sleep, and that they'd not even eat there. So to be put in the position where that became their world, I think it's really impacted on people, everybody's, but particularly young people's mental health as well. So, you know, lots of law firms are working hard to support the young lawyers through all of this. And it is a work in progress. It's not a finished product yet, and that will take some time.
Yeah, I totally agree. As a result, do you think that there might be an increase in, let's say, for example, employment or tribunal cases as a result of some employers taking advantage of the furlough scheme?
Oh, I've heard so many different stories, and it's really quite challenging. We were really firm with our clients about how they should apply the scheme. The rules were very clearly set out. So if people could work at all and could work from home, then they should continue to work. If they couldn't work from home and there was no work, then they could be placed on the furlough scheme. There have been a whole raft of companies, and we're seeing some cases coming through now in the UK, that applied for the scheme whilst they had their employees working. So it has been misused. And like any initiative, you are always going to get people who are looking for an opportunity to make a quick buck, to bend the rules. You know, that's life, isn't it? People have choices, and sometimes they make bad choices. So it has been abused by a very small minority. The furlough scheme has cost the UK government more than £100 billion since last March. So that's a huge amount of investment in the economy. And unfortunately, for generations to come, the younger people are going to have to start be repaying that. That's a really unfortunate situation for young people to be placed in. But, you know, we have heard from the Bank of England that the recovery is going to be sharp, and by the end of this year, we should be seeing the same levels of the economy as back in 2019. So I think there are lots of green shoots. There are lots of moves towards regenerating the economy, but you know, there have been some abuse of the furlough scheme, and the government have recruited many thousands of inspectors to check and audit the scheme. So, you know, there are going to be big fines, and, you know, that's what we do in law, isn't it?
Personally, I know a few people who have been, well, succumbed to such a situation where, you know, they've been placed on furlough, but the employers are still asking them to work, you know, and, you know, some of those employees feel powerless and helpless in such a situation because, you know, they don't want to lose their job and, you know, to be totally without an income. So do you have any advice to any persons who may be feeling, you know, helpless or, you know, or powerless in such a situation?
So we've advised some people in that very situation who have contacted us to ask what they should do. And it is a really difficult situation because individuals want to be honest. They want to, they know the rules. We all know the rules because they're very well talked about on every government briefing that we have. But they also want to retain their employment. So what we've advised people to do is to write to their supervisor, their employer, by email and say, well, I understand that you've placed me on furlough, but you've asked me to do this work. I just want to be sure that I'm not going to break the rules. And if you tell me that you'd still like me to do the work, then I will do that because you've asked me to do it. But I would prefer that we apply the rules, but I'll be guided by you. So really put the onus back onto them. If there isn't an investigation going forward, then that can be displayed as an evidence that you're not complicit in breaking the furlough rules. It's a very uncomfortable position to be put in, and it's not just the legal sector. If it happens in the legal sector, I'm very disappointed. It probably does, but it happens certainly in other sectors. And I know in hospitality, a lot of people are working and claiming furlough. And, you know, the reality is that they will be investigated and they will be fined, and that's an unpleasant situation. So if law firms are doing that, then I would urge them to reconsider applying for furlough and asking people to work, because certainly in the UK, they'll be in breach of the SRO rules, and that will have a significant impact.
Okay, great. So let's talk a little bit about the impact COVID-19 has had on health and safety. So we've been working from home, and as a result, the boundaries between our home life and our work life have significantly blurred. Could there be any potential claims against employers in relation to an employee's working environment? So let's say, for example, if you're in the office, you trip and you fall over a cable, you know, the employer is liable. Would the employer have a similar duty of care if the same were to happen to an employee during the course of work, at home, as they're working from home?
So there's very clear guidelines, regulations, health and safety regulations that apply to an employee working in the workplace or from home. And there is a duty of care that owed to all employees under Section 44 of the Employment Rights Act. So that absolutely applies. Now, at the first and second lockdown, when people were restricted from going into people's homes and so forth, or anybody else's home that wasn't within the bubble, then it was really difficult for any sort of health and safety audit to be undertaken. Lots of law firms and lots of businesses were providing information to individuals, to employees, to make sure that they were working in a safe environment. As to whether the individuals followed that through, that's a matter for them to ensure that they were working in a safe environment. That's not the end of the conversation though, because of course, you know, if people weren't set up from home and they didn't have a space, I'll come back to the young professional working on their bed, on the side of their bed, or in a desk in their bedroom. That really isn't a suitable environment, although it might be the only place that they've got. And we are going to see going forward not only significant increase in mental health issues, but also in terms of physical issues with back, with people who have created a problem for parts of the way they're sitting down, and for not working from the right equipment. So I think there is going to be an increase in potential claims. The due diligence that an employer would apply is that if they'd counselled their employees to work in a particular way, and if they provided desks or laptops or chairs, which has happened for a lot of law firms, then they could say that it's then down to the individual to make sure that they're working in a safe environment at home. Tripping over a wire, you know, that could happen anywhere. Yeah. And if the wires are, you know, like a spaghetti wire in a house, then, you know, you are more likely to trip than if you've got, if you're more sensible. And there has to be a degree of being sensible about all of these things.
Okay, yes, I completely agree. So mental health, you've touched on that. Let's talk about it for a minute. Mental health and well-being has been in the spotlight, even more so. Due to the pandemic, the term burnout has sadly becoming more prominent, and as there's less division between the home and work environment. What advice would you give young lawyers to improve their ability to detach and understand their right to disconnect from their work environment at home to protect their mental health?
Chloe, that is a really interesting one, because you and I both know, as we rise through the profession, we want to show our commitment, and very often lawyers, it's not perfect, but we deliver ourselves to more hours than a 9-to-5 arrangement in order to progress our career. Working from home, that's no different from the point of view of we have our contracted hours, and generally we work a bit longer than our contracted hours because we've got a piece of work that we want to finish. And that goes with the career. It's a vocation, isn't it? Being a lawyer, it's a career, it's not a job. So we see that when we join the profession, so we know that. But I really do agree with you that people have been working very much longer hours for a whole host of reasons. Nobody's telling them to stop. They've got nothing else to do. You know, in lockdown one here, there was nothing else open apart from, well, nothing was open apart from supermarkets. So people were therefore throwing themselves into work. So it's down to managers, team leaders, owners of businesses to really work hard to encourage workers, employers, lawyers to work defined numbers of hours, that check on them, make sure that they're taking regular breaks. And that's a real management tool and skill and obligation. So if they see somebody when they get there, when managers are getting feedback onto productivity, that somebody's working 10 hours a day on something, 12 hours a day, then those are times when employers have an absolute obligation to dive in and say, what's going on? We need to pull you right back. We need to manage you. We do not want you working these sort of hours. So you've mentioned the right to disconnect. It's really interesting that. And, you know, there is a movement across the world for employees to be able to say, I've done my hours, this is it, I'm disconnecting. And a lot of law firms in the UK, as in everywhere in the world, there are global clients. So there'll be clients in the US, different time zones. So consequently, you know, people are having to work different hours to accommodate their clients who may well be from the UK into the US. And pre-COVID, that happened, and that was expected if you worked in teams that had international clients. But you'd take time away and you'd balance it out. Whereas post-COVID, working from home, there is no cut-off point, is there? So the right to disconnect is a really important value and right, and it's actually something which is proactively proposed by a lot of organisations in the UK. And it was considered in the employment bill this year as an option, or as a conversation or a consultation piece. It didn't make it into the employment bill this year for a number of reasons. My view on that is that this is the wrong time to apply a right to disconnect. There are a lot of people working who enjoy working from home and enjoy the flexibility of working from home. So a lot of lawyers, and we're talking about lawyers, may well say, well, I'm going to work from 6 in the morning till 10, and I want to take a few hours off and I'll finish my day in the evening. So that's fantastic because they're doing their hours, say 8 hours or however many hours is required for their particular role, but not in a straight 8 hours, but working to their own needs and to other things that they might want to do in the day. And so applying the right to disconnect will be very prescriptive for somebody, for a manager to be able to say, or for you as an employee to be able to say, well, I've worked my 8 till 6 today, and so if you contact me at 7, then actually I'm not going to pick up, and because I've disconnected, I've done my hours, and that's fine. However, if you're working more flexibly and working your hours around other commitments in the day, so for example, homeschooling, or if you want to pick up your children from school, if you're a parent, then that right to disconnect becomes very blurred as to when you've actually disconnected. So unless you're proactively saying to your manager or your supervisor, well, tomorrow I'm working these hours every single day, then the right to disconnect doesn't work at the moment. And it actually prevents flexibility rather than enhances the right to disconnect just now. The conversation is a conversation waiting to be had when we're all back to some sort of new norm, and we're not there yet. that's probably a conversation for 2022.
Yeah, because it's important, because, you know, young lawyers today, I actually know some colleagues who they feel pressured per se, because then they want to impress their supervisors, they want to get the task done, but at the same time, there are other young lawyers who are vying for their position, who are also working just as hard and putting in the extra hours. So, you know, one day you might work from 8 and the next day till 9, and then, you know, it just progressively gets later and later. And, you know, it's very important for that, for young lawyers to understand that, you know, it is important to disconnect from your work in order to protect your mental health, and also to, you know, produce quality work product.
Yeah, and that's a matter of still conversation. You know, it's absolutely imperative that communication piece is had, and that's down to not only the young lawyers who need to be honest, but also more importantly down to the supervisors. They need to be more proactive in terms of supporting people's mental health, because, you know, being a lawyer is really hard work. You've got clients, you've got targets, you've got supervisors, you've got a whole host of obligations to deliver. And then you need to know the law on top of that. So you've got to train and continuously keep up to date. So there's no doubt about it that even outside of COVID, being a lawyer was a very pressurised career. It's rewarding, but it's pressurised. So that's compounded by COVID. And when people are in an office, people around, colleagues, supervisors, can see when a young lawyer's taking on too much. And that's been less visible when people are working from home. So that's why the communication from a supervisor is really, really important. And supervisors have the responsibility and the obligation to ensure that their team are working to capacity, but not over capacity, not overextending themselves. Because claims will come through, and they've started to come through, not necessarily from the legal profession, but other sectors where employees are starting to deteriorate and suffer with some significant mental health issues.
Okay. And just to wrap up, any advice you want to give young lawyers listening today who might be interested in pursuing a similar career path to yours?
Well, I would go on about employment law all day long because it's amazing. So I love employment law because you're dealing with real life situations, people's lives. People come to us, employers and employees, where they're at the real desperate stage of their lives. And if you're a problem solver, if you're a lateral thinker, if you're quick on your feet, if you like tight timescales and tight limits, so it's 3 months to raise a claim in the tribunal, so you really need to be quick, and you like to know the technical side of the law, and you're making a real difference for people, then you would love employment law. There are processes, but it's an entirely different area of law to conveyancing. And both are fantastic, but for me, people making a difference, changing people's lives is just so rewarding for me still, that I would advocate employment law every day. Coming into the legal profession, you know, it's just the most exciting profession that I think that you could have the privilege of working in. We take responsibility for people's lives from birth to death and everything in between as a lawyer. It is a profession that's well respected. You have to work darn hard. You can't just come in and feel that you can just coast because you've qualified. I don't think any of us realise that, do we, Chloe? You know? And so many opportunities. For me, goodness me, I've been to the opening of legal part of the legal year, down in London, with the good and the great of the legal profession. You know, it's just extraordinary. I've been all over the world as a lawyer, which I would never have done in any other career. So I've worked in Barbados, I've worked in America, I've worked in Europe, and I've spoken in the European Parliament. as a lawyer. So all of these are great opportunities, you know, and they're there for the taking. I don't think anybody's going to say to you that if you're determined to achieve as a lawyer, then that people aren't going to stop you. So I would say it is hard work, it's incredibly hard work. And when I had 2 young children, I brought them into my office at the weekends. I don't advocate that, but that's what I did. And they did my filing whilst I was doing my client work. So it was it was fantastic. I'm not sure what they would say about that now, but that's what I thought. So yeah, I think it's a very honourable profession, and I would welcome anybody to join our profession and be more than happy to support people as I do.
That's fantastic. All right. Eileen, thank you so much for your time. It was a lovely and a pleasure speaking with you today. You have given us tremendous insight, not only into your personal path, but the impact COVID-19 has had on employment and employment law, and the issues of furlough, the history of furlough. I for one, didn't know that it was an American history behind that. And also, the advice you've given to young persons. Thank you so very much, and thank you all for watching.
Thank you. It's been my privilege and pleasure. Thank you.
Thank you.